Well, good evening, everybody. Thank you for coming out on this snowy night. My mom was a librarian, so it always is great for me to be in a local library. It looked a lot like this, actually. And I had a brother who was a librarian, too. As Gloria suggested, I've had the real good fortune to have 3 different professional identities. I've been a practicing lawyer since I was admitted in Illinois in 1979 in my hometown, Chicago. And I have, in fact, remained an active litigator for now well over 40 years, arguing cases all over the country on constitutional law issues. And there's nothing I love more than doing that, and I still do. And I'm involved in some fascinating cases right now. And I've been an academic. I'm not even sure Gloria named all the schools. That's like that Johnny Cash song, you know, I've been everywhere, man. I've been everywhere, all over the country, as a faculty member at a lot of different American law schools. The dean of 3 law schools. I was president of Vermont University. Now I'm so fortunate to be in this beautiful state as the president of the Vermont Law and Graduate School. And I've also been a writer. And I've written professional works, legal treatises. I take care of 5 legal treatises. But I also write for popular audiences, and what I've often done, and find to be a lot of fun, is if I get involved in an unusually exciting, interesting, colorful case, I'll be a litigator in the case, and then I'll use it when I teach students, and then I'll write a book about the case sometimes. And in at least 1 or 2 instances, the book's become a movie, so it's been a lot of fun. I mentioned that I maintain these treatises, and I have several treatises that deal with free speech issues, and I have one big one on free speech that's 3 volumes long, 27 chapters, something like 3,000 pages. So why would I bring that up? Because ridiculously, American free speech law is unbelievably complicated. It's almost as complicated as the tax code. You wouldn't think it. It's only 1 sentence, the First Amendment, and you wouldn't think it would be that complicated. But the way our society has evolved, there are, as I said, 27 chapters, a whole plethora of different legal doctrines, very dense. But I'm not going to walk you through any of that tonight. I'm going to just tell some stories. I'm going to tell some stories about a few of the colorful cases that I have been involved in as a lawyer and written about, because I think they'll evoke a lot of the main themes and controversies and debates we have in this country about what free speech means, which is the title of the talk. So I'll talk for a bit, tell you some of these stories, and then I'll be delighted to take your questions, have some dialogue, exercise our own free speech rights. And for all the folks that are watching on streaming video, you can pop questions. There's some way that they can get to me, or send me an email if you want, and I'll try to answer it that way. So the first story I'm going to tell you about is one of the most fun cases that I ever have been involved in. It went to the U.S. Supreme Court. It's a case called, in the Supreme Court, it was called Falwell versus Hustler magazine. And so this is a case that pit 2 of the most extraordinary characters of their time against one another. On the one hand was Reverend Jerry Falwell from Lynchburg, Virginia, founder of Liberty University. Reverend Falwell was truly one of the most influential figures of his time at the height of his fame in the United States. There had been, of course, radio and TV preachers since the dawn of broadcasting, and there was the famous towering televangelist Billy Graham from Charlotte that really sort of paved the way for these giant mega churches that would have programs that millions of people would watch on a Sunday morning. Reverend Falwell turned that into an art form with his Sunday broadcasts, the old-time gospel hour. But probably even more importantly, although Billy Graham was in a sense a crossover artist, and that Billy Graham would always be invited to the White House. No matter what the president was, one of the first people you had to bring in was Billy Graham. And he had this kind of elder statesman quality, this rational, balanced quality. Reverend Falwell was willing to really enter what we now think of as the culture wars, back when they were just beginning to crystallize. And he unabashedly, to the criticism of some and the praise of others, felt that it was his moral duty, his religious duty, his obligation to use the church pulpit, not the Teddy Roosevelt bully pulpit, but the pulpit of his church, which had this tremendous amplification because of television, to constantly enter the cultural and political arena on matters that divided the country culturally and politically. Reproductive rights, abortion, sexual orientation, and very powerfully, pornography and obscenity. And Reverend Falwell railed against pornography, and indeed there was this very curious moment in American history in which there was a tremendous broadside attack against sexually explicit material, fueled by two different parts of our cultural spectrum. There was a feminist attack on pornography and obscenity that was gaining tremendous traction academically and culturally. And then there was this attack from the evangelical right, from Reverend Falwell. So that's Jerry Falwell. I had the pleasure of meeting him, getting to know him. I'll tell you a bit more about that down the road. The other character, the other dramatic actor in this drama was Larry Flynt. Now, Larry Flynt passed away a couple of years ago. I was interviewed a lot when he passed away because I had been in this case and written a book about it. And I'm in Larry Flynt's book. He actually likes me, and because I was involved in this case. Some of you may think that's good. Some of you may think that's bad. Be a Larry Flynt fan. So who was he? Well, if you've seen the movie People vs. Larry Flynt by Milos Forman and Roger Stone and Oliver Stone, and it featured Woody Harrelson as Larry Flynt, you may have a sense of who he was. Some of you may know just from your memories of culture and history. But here's how I would describe him. You know, of course, that slick sexual magazines were big business and very popular and very sort of avant-garde in the 1950s, but particularly 1960s, 1970s. And the two famous magazines were Playboy and Hugh Hefner's Playboy clubs, and Penthouse, led by Bob Guccione, who was the sort of rival to Playboy. And these two pornographic magazines were fascinating in that they weren't just hardcore sexual depictions of naked women and erotic stories. They also wanted to be part of high culture. They wanted to be like Esquire or Cosmopolitan. And so the magazines would spend a huge amount of money to get some of the famous writers of our time to do pieces in the magazine. You might see Joan Didion or Norman Mailer, or Hunter S. Thompson writing pieces in these magazines, sometimes on topics that had nothing to do with sexuality, nothing to do with sex. There would often be kind of also very high-end advertising and accompanying articles. Remember, this is when there were stereos. You all know what that was. A lot of my students have no idea what I mean by that. But there would be reviews of what are the best speaker systems for your listing room and stuff like that. So there was this kind of attempt at high culture coupled with sexuality. Larry Flynt, who grew up running strip clubs in hill country in Kentucky and Ohio and Appalachia, he didn't get it, all right? He didn't get why on earth anybody would want to read something by Norman Mailer in what he would call a girly magazine. What's that about? His strip clubs were just beer and whiskey and sex. And that's what he wanted to do with Hustler magazine. So he created Hustler as a kind of blue-collar insurgent entry into this market. Well, Bob Guccione hated him, and Hugh Hefner hated him. Like he was giving pornography a bad name, you know? And if you actually look on a legal database and search for lawsuits involving somebody connected to Hustler, like Flint or Hustler, and Penthouse or Guccione or Playboy, they sued each other all the time. And of course, Larry Flint was constantly being pursued by authorities for publishing obscenity. So he had a troubled legal history. Well, although Hustler didn't have much in the way of culture in it, they did have a joke page, and they did sometimes have clever visual parodies. And so this lawsuit came about when Hustler decided it would be fun to do a parody of a Campari liqueur ad featuring Jerry Falwell as the prominent celebrity in the ad. Now you need to know a little bit about Campari liqueur. Some of you maybe have had it, many of you maybe have not. Italians love it, Europeans love it, but it's an acquired taste. It's a very bitter liqueur. So, you go to Italy, it's just a nice cafe, what do you want? You order a Campari, you feel like you're right there, with Sophia Loren or something. But Americans didn't like Campari because it didn't seem to fit the American palate. So the marketers of Campari came up with really one of the great ad campaigns in advertising history. They would take out these very, very sophisticated and glossy and interesting one-page ads in, again, the best magazines, in Vogue, in Cosmopolitan, in Esquire. You'd even see them in crossover magazines like Newsweek or Time. And the ads always followed this format. There'd be a famous figure, a famous athlete, or a famous movie star, a famous singer, Jill St. John, for example. And there'd be the picture of the celebrity, and then there'd be an interview. And so there's the picture of the celebrity, an interview, and then this very delicious looking bottle of Campari and a little drink, showing the Campari on ice. And the interviewer would ask the celebrity about their first time. And the first time was always some exotic, romantic, interesting story. Oh, I remember my first time on a beach in Saint-Tropez. And then the interviewer would say, wow, what was it like? And the celebrity would always say, well, really, it wasn't that great. But over time, it got better. And the message was that sex, like Campari, gets better with practice, all right? Very clever. Well, here comes Hustler with its high-class humor. So Larry Flint says, let's ask the Reverend about his first time. Now, that wouldn't be so bad. That would be a nice chuckle. Some of you are laughing now. That could be on Saturday Night Live or something, right? Except it was the most crude, mean, vicious, vulgar interview you've ever seen in your life. Reverend, tell us about your first time. Sorry, folks. I hope this doesn't get censored on the internet, all right? His answer, with my mother in an outhouse in Lynchburg. Oh, my God. And then it gets worse. I can't even go beyond that. When I teach this class, I have to be careful. I have to ask myself, should I let the law students see this or not? They look at me like I'm a fool. Are you kidding me? Well, this is nothing today. But for the time, it was horribly offensive. And Reverend Falwell, who grew up an atheist, who grew up not believing in God, and then had a conversion experience while in college and became a man of the cloth, Reverend Falwell idolized his mother as a saint because she was a believer. He and his father were not, But when she had the conversion experience, it was not just the natural bond between mom and a child, it had this religious resonance. And she had passed away at the time of this ad. So there's the story. Falwell is at the Willard Hotel in Washington, one of my favorite hotels. You're going to hear about Abraham Lincoln next week. That was the place where he stayed on the eve of his inauguration. One of Falwell's aides hands him a copy of the Hustler magazine. Now you might ask, what was Jerry Falwell's aide doing with a Hustler magazine? I don't know. That's not in the record. We don't know the answer. But Falwell gets it. He sees this, and he is apoplectic. He is overcome with anger, overcome with outrage. You can understand it. So he decides he needs to sue Hustler magazine and Larry Flynt. He needs a good lawyer. Now, Falwell, as I've already mentioned, had constantly been in litigation against Penthouse. Penthouse and Bob Guccione had a bombastic, blowhard lawyer. He's since passed away, so I can get away with saying that, all right? I mean, he really was. He was over the top, kind of full of himself. He went to Yale Law School, but I mean, I'm telling you, a bombastic, over-the-top lawyer who loved to sue Larry Flynt and loved to sue Jerry Falwell and would constantly win against Falwell on behalf of Penthouse. Falwell went and hired Bob Guccione's lawyer. He hired the lawyer for Penthouse. And I think it was like, if I'm going to sue the devil, I want a devil as my lawyer, you know? And the two got along great. Falwell took the ad and showed it, this is the parody, and showed it on television. Now, he blacked out the worst vulgar words. And within weeks, had amassed this huge war chest of money as people sent in the donations for him to sue Hustler magazine. And if you think about it, all these Baptist believers who love Jerry Falwell are sending money to Penthouse's lawyer, okay? So, some of you may remember the Iran-Contra diversion. This was sort of like the Baptist to Penthouse diversion, all right? So they amassed this war chest, and they filed the suit, all right? Now you got to use your thinking caps a little bit. Well, what do you sue for? What do you sue for? Well, your most natural instinct would be defamation, would be libel. Of course it's false. Of course Jerry Falwell never had sex with his mother, never had sex in an outhouse, didn't do any of the vulgar things. So he should, you'd think, have a suit for defamation. He also tried two other theories. There is a body of law that says you cannot take a celebrity's face or their name and use it to sell a product. You can't take LeBron James or Michael Jordan or Lady Gaga and put them on, you know, a detergent box without paying them, all right? People get paid a lot to endorse products. And so the theory was that Falwell's likeness had been taken and his name had been taken to sell a product. So that was the second theory. And then I later, when I interviewed Mr. Grutman, I later found out that 1 hour before they filed the lawsuit, one of his hotshot young lawyer associates in the law firm in New York, researching things at the last minute, you know, frenetically, before you got to get the papers in court, discovered that Virginia had a tort, a legal cause of action, a civil cause of action, for intentional infliction of emotional distress. A really interesting legal theory. And what it requires is that you intend to inflict severe distress on a person, so you have to intentionally do it. The stress has to be severe, and your conduct has to be outrageous, which the restatement of torts, the kind of sporting news or Bible of tort law, had this theory that what we mean by outrageous is it's intolerable in a decent society. And so Norman Roy Grutman, the big lawyer, says to the associate, yeah, hell, throw that in. That sounds right. We'll put that in. So then what happened? Well, the case gets tried in Roanoke, Virginia. It's hill country. That's the area that Jerry Falwell is from, in front of a terrific federal judge, Judge Turk, who I later would become friends with in an interview. And Judge Turk, on his own, throws out the appropriation of your name thing. He says, no, you can't do that. No one thought that Jerry Falwell was really selling Campari liqueur. Campari didn't make up this ad, Hustler did. Everybody knew it was a joke. People have used people's faces for fake commercials, since comedy began. That's not what this tort is for. I'm tossing that one out. He then let the jury decide whether the parody was actually intended to be understood as an assertion of fact about Jerry Falwell, or was instead intended as humor, as a joke, as an insult, but not to be taken literally. And he let the jury decide that. And the jury correctly, I think, said, nobody really believed this really happened. Nobody really believed that Hustler was claiming this actually happened. In the contents of the magazine, it listed this page. You probably wouldn't think Hustler would have a table of contents, right? But it said parody. It said that. The actual advertisement said parody. And all you had to do was read the first line, and you knew this. He didn't say that. Of course not. That's ridiculous. So the jury got it right. Then Judge Turk instructed the jury on the emotional distress claim. And I've already told you what the rules of the game there are. I'll give you two of the fascinating moments from the trial. In the trial, Larry Flynt is shown in a videotaped deposition. He was also shown live, but they showed the tape and they showed it live. At the time of his deposition, he was sort of insane. He had been the victim of an assassination attempt. He was paralyzed. He was in pain. He was in prison. He was out of control. When he was deposed, he kept constantly getting radio signals from Vietnam. And so he'd be asked a question, and he'd start answering, and then he'd go, "Bravo, Charlie, bravo, Charlie." And it was just unbelievable, like a circus. But here's a key moment. Norman Roy Grutman, who hates Larry Flynt, and Larry Flynt hates this lawyer. Norman Roy Grutman says, "Did you understand that Reverend Falwell was a preacher and a moral leader, and that for people to believe in him, he had to have a character that people believed in?" Answer, yes. Was it your intent to damage that character, to hurt him in his profession, to hurt his character? Answer, to assassinate it. How'd you like to be Larry Flynt's lawyer? You got to defend that. So the jury comes back and awards $200,000 in damages against Larry Flynt and Hustler in favor of Jerry Falwell. Now, it's not that much money. It's decent, but it's not that much money. I doubt it paid for the attorney's fees. I'm sure it didn't. It's kind of a symbolic victory, but it was $200,000. The verdict came down, and I was still a relatively younger lawyer and law professor and litigator in Virginia at the time. I was at William and Mary. And I thought the verdict was a serious affront to free speech. And my thinking was, think of all the times that famous people get pilloried either by serious attacks on an op-ed page or by humor, skits on Saturday Night Live. I mean, imagine, all the things you've seen in our culture attacking famous people, sometimes seriously, sometimes semi-seriously or humorously, that would cause most of us a lot of distress. Is that all it takes? The Supreme Court had previously started American First Amendment law down a very important line of decisions in which the court had said if you libel a public figure or a public official, there is no liability unless you do it with what's called actual malice, which doesn't mean what you think, malice in the ill will sense. It means that you know it's false or you speak with reckless disregard for truth or falsity. That's almost impossible, an impossible burden. I've litigated that issue many, many times, often on behalf of plaintiffs. It is almost insurmountable. I currently am involved in a very big case, one of the biggest defamation cases in American history. I'm the academic lawyer on the team of people that represents Dominion voting systems. We use those in Vermont, the voting machines that Donald Trump claimed through the election in favor of Joe Biden. There's a lot of people that Dominion has sued, Rudy Giuliani, Sidney Powell, quite a few people. But the biggest case is against Fox. I argued that case. I argued the case on behalf of Dominion against Fox when Fox tried to get the case tossed out. I can talk to you a bit about that later. That's a rare example of being able to meet the First Amendment standard, at least at the first stage of the litigation. But I thought, well, look, if all you got to do is prove your feelings were hurt real bad, and a lot of people would call it uncivilized or outrageous or indecent, it's an end run around that whole body of law. And a real threat, not just to Hustler magazine, but to the New York Times and CNN and, you know, Mad Magazine and you name it. And I happened to be invited to be the keynote speaker at a convention of media lawyers and journalists. And this verdict had just come down. And I used the case as my speech. I talked about it. So this is one of those things happens in the movies. I'm leaving, and a bunch of these people in real nice suits, a lot better than what I was able to afford as a young professor, come up to me and say, Professor Smolla, we'd like to talk to you. And one thing led to another, and before I knew it, I had my first big gig representing the New York Times, Los Angeles Times, number of broadcasters, number of media outlets, and they were convinced, because I said in my speech, I know most of you don't want to touch Hustler magazine with a 10-foot pole. I know most of you do not want to go into court on behalf of Larry Flynt. But there's a big issue here. In First Amendment law, we often represent people that we think are sickening and despicable. You need to step up and do that here. They did. So I'll end the story pretty quickly. All the briefs were written. I wrote the brief. I got to be friends with the lawyers for Larry Flynt. I had a civilized relationship with the lawyers for the other side. The day came for the oral argument in the U.S. Supreme Court. The U.S. Supreme Court is an amazingly intimate space. So if this is the podium, the justices are closer than the front row right here. The justices are only like 8 or 9 feet from you. It's surprisingly intimate. A lot of appellate arguments are that way. It's great. And I was sitting behind the advocates for Larry Flynt. There was a question as to whether the Supreme Court would let Larry Flynt attend. Because the last time he had been in the court, when the court came out in that majestic opening ceremony, Larry Flynt screamed obscenities, including vulgar, misogynist obscenities directed to Sandra Day O'Connor. And this was in his insane period. And he was dragged out by federal marshals screaming. Again, how'd you like to have him as your lawyer? So how'd you like to have him as your client? So anyway, Chief Justice Rehnquist wrote back and said, Mr. Flynt is welcome to come. Of course, we hope he will behave himself. And his lawyer had said he was crazy before, he's back, he's normal now, and it was basically true. And so I wasn't arguing the case, and it's one of the, it's like the moment before a ball game begins. The crowd is restless, and it's, everybody. But you have a little more fluidity if you're not actually the person at the counsel table arguing the case. And I look behind, and I see Larry Flynt in the back row because he's in a wheelchair, and he has a wheelchair nicer than most people's homes. I mean, he's got it's like a $500,000 wheelchair, gold plated, and Probably had DirecTV on it or something, you know. But anyway, and right next to him is Jerry Falwell. So I walk up and I say hello to Mr. Flint and I say hello to Mr. Falwell, both very kind. They seem to have kind of a nice chemistry to each other. I was like, what the heck is this, you know? But they seem very cordial. And so I went back then, that's something. So the argument happens and it's very tense, very tense. And the lawyer gets up who represents Hustler and the lawyer gets up who represents Flint, and they're going at it. Well, I had become friends with the lawyer for Larry Flint, who was a Boy Scout. He was about 35, 40 years old at the time. He looked like Dookie Howser. He looked like he was 12, all right? In the movie, he's played by Ed Norton, a young Ed Norton, and that's how the lawyer, Alan Isaacman, really looked. He didn't drink, he didn't smoke, he hated obscenity, he loved the First Amendment. He went to Harvard Law School, he was a First Amendment crusader. He's got Larry Flint, his crazy client. He was arguing the case. And he was getting hit pretty hard. And Thurgood Marshall, for example, was really coming down hard on him. And as tense as could be. And then there's this moment when it was Justice Marshall, Thurgood Marshall, says to Alan Isaacman, yeah, we believe in criticizing famous people. We believe in criticizing public figures. We believe in protecting, you know, intellectual content. But I don't understand what there is about this ad that deserves any First Amendment protection. What was your client trying to say? He had sex with his mother in his house. What was your client saying here? That's worthy of protection. And there was silence. And my friend Alan seemed to fumble for a second. And then he said, my client's view is that Jerry Falwell is a windbag, he's pretentious, and that this is all bullshit. And like the whole Supreme Court, everybody's, my God, did he just say bullshit in the Supreme Court? You can't do that. I was like, oh my God. And then my friend Alan goes, and he's trying to bring him down to our level. And he put his hands out like this, our level, like he's pointing to the justices. Like, oh my God. And there was silence. And all of a sudden, the Chief Justice, William Rehnquist, burst out laughing. And laughed so hard, he fell below the court and back up. And the second he laughed, the entire Supreme Court just started laughing. The whole courtroom started laughing. And it was like giggling in church. Everybody was laughing. And I'll never forget, I whispered to another lawyer sitting next to me, old friend Rosalind Mazer, who'd written one of the briefs. I said, we just won the case. Because if they could laugh, they could take a joke and realize that Jerry Falwell had to take a joke. Shockingly, it was a unanimous opinion in favor of of Hustler magazine, Larry Flint. Two little after pieces to this story. The two of them later became friends. And Flint treated Falwell as his pastor. And they went on tour together. They would do college gigs. And I got invited to be the moderator at a great one at the University of Virginia. And in the back room, before we had lunch, the two were loving each other up. They were having a ball. Then they went on stage, they went on character, but it was still fascinating. I decided it was such an interesting case that I wrote a book about it. And I tried to make the book colorful. And I got a call after the book came out. It was published by St. Martin's Press. I got a call from a Broadway producer, a man named Lewis Allen, who had done a number of well-known Broadway shows. He had done some serious things, like A Few Good Men. He had done Annie. I mean, he was a well-known, successful Broadway producer. He said, I'd like to buy the rights to your book and make a Broadway show out of it. You have an agent. And I go, well, no, Mr. Allen, I represent myself. He says, well, would you come to New York and talk to me about it? We ended up talking 2 or 3 times. He said, you know, you're kind of a creative guy. Would you like to try your hand at writing the show? I said, oh, I would love to. I'd love to. So he said, you try it. You see if you can make this into a Broadway play. So I wrote a first draft, sent it to him. He said, I like it, it's missing something, try again. His wife, who was a screenwriter and a playwright too, looked at it and she tried to tell me what was wrong, but I couldn't get it. So then I write a second draft. And he says, oh, it's almost there, but still it's not quite good enough. But I don't know what's wrong, I don't know what to tell you. Let me get one of my playwright friends to read it and talk to you. Let me see if Arthur Miller's available. Wow, yeah, sure. Arthur wasn't available, all right? This was, I think, after Marilyn Monroe, but he wasn't available. But here's the deal. He said, I have somebody that I'm going to put you in touch with. His name is Calder Willingham. Do you know who that is? I go, no. And then he rattled off a bunch of famous movies that Calder Willingham had written, like The Graduate, a talented writer. He's the one who wrote the line, plastics, all right? Calder Williham's a sort of a Southern intellectual writer living in New York. I had lunch with him. He says, it's easy. Here's what's wrong with your play. It's not an even fight. You make Larry Flint funny, colorful, kind of obscene and vulgar, but in a full, attractive character, and you make Jerry Falwell look like an ass. You make him look like a stiff-board character. It's not an even fight. I got it instantly. And I went back and wrote a third draft. And I tried to kind of make Jerry Falwell kind of like a Jerry Lee Lewis, you know, kind of like a because he actually is pretty charismatic and pretty funny and pretty interesting, and make the fight even. And the big device I used was I had a chorus, and the chorus would haunt each of these two characters. And when the chorus was in Larry Flint's dream, they were a gospel choir, and they would haunt him. And then when they were in Jerry Falwell's dream, they took off the robes and were strippers, and they would haunt him. I thought it was a pretty good touch. So this time, Lewis Allen liked it. He said, we're going to get some actors, we're going to get some directors, we're going to try to get investors. We're going to rent a dark theater in Broadway. Theater is in between shows. They got a stellar crew. They got William Macy to play Jerry Falwell. They got Peter Boyle, who passed away a while ago, but a colorful figure, to play Larry Flint. They had the director of Jesus Christ Superstar as the director. And they had 400 people, investors, private investors, people like HBO, et cetera. They did it. It was like everybody loved it. Lewis Allen took me around town, took me to the Russian tea room to meet Mike Nichols, you know. I thought I was going to be rich. No longer am I going to be a lawyer. I'm going to get my black turtleneck. I'm going to live in Greenwich Village. This is going to be my new life. And it was ready to roll. 2 weeks after, Mr. Allen calls me. He says, the project's dead. Oliver Stone and Milos Forman have just announced they're going to do People versus Larry Flint. They got Woody Harrelson to play the main role. You know, they got Courtney Love, and we can't compete with that. So I was crushed. I made myself go to the movie when it came out. In the movie, and in the tagline they used to advertise the movie, if you rent this on Amazon, or you'll see it, Woody Harrelson, who I love as an actor, he plays Larry Flint. And in this key moment, he is chewing out his lawyer, Alan Isaacman, who he was always firing. You're fired, Alan, you're fired. And then he'd hire him back, the next day. So there's this moment when Flint's on a plane. He's looking down at his lawyer, and he's saying, Alan, I'm your dream client. I'm rich, I'm funny, and I'm always in trouble. You laugh, it's a great line. In real life, the real Larry Flint never spoke those words. That's the opening sentence of my third chapter. I said, he was a dream client. He was rich, he was funny, he was always in trouble. So Oliver Stone read my book and stole my line, all right? When my dad heard about it, so they said, you're going to sue? I said, Dad, if I do, we'll never work in this town again. He said, well, at least you're getting ripped off by a higher class of people. So anyway, all right, I'll tell you one other story because I want to make sure I have time for all your questions. I'll tell you one other story. I had three, but I'm only going to tell you two. And between the two of these, we'll be ready for our debate. So about half the time in my roles as a litigator, I have been defending free speech principles. I argued a very controversial case in the Supreme Court defending free speech principles. But at times, I have been on the opposite side, arguing that the particular speech at issue does not deserve free speech protection. And Anya, my wife, who's here, has seen me do this a bunch of times in a lot of recent colorful cases, a number of them involving Netflix, in which Netflix takes real events and fictionalizes the events, but you think you're watching the real thing, and then they say things about real people that didn't happen. Really cutting edge, interesting, unusual area of the law. Jeremy Peters from the New York Times just wrote a really interesting piece about that, and some of the cases he wrote about were cases that I'm in. So that's when I've been saying you crossed the line. So here, I'll tell you one other case where I said you crossed the line, and a lot of people disagree with my position in this case, just like they disagree with my position on the other side. So here's the case. I got to start with a story. Story involves a couple that had an extraordinarily tumultuous romance and marriage. They'd be married, they'd get divorced. They'd be married, they'd get divorced. They would go back and forth between being together and not being together. In the course of that, they had a number of children, and I'll have to tell you about that. The man's name was L.T. Horn, Lawrence Horn, and the mom's name was Mildred, or Millie Horn. Millie was an airline attendant for American Airlines. L.T. was one of the creators of the Motown sound in Detroit. Now, he wasn't a writer or a producer like Smokey Robinson, but he worked with people like Smokey Robinson and Stevie Wonder and Four Tops and all the famous acts of Motown as the principal sound engineer. He was also a DJ in Detroit in the early days of Motown, and he was called L.T. Horn, the man with the plan. If you listen to him, he created the sound. Like it wasn't Diana Ross, you know. There wasn't Smokey Robinson. It was really all his work. But I'm sure he had a lot to do with it, and he was really a highly regarded sort of sound engineer producer in Motown. The two had this tumultuous relationship, and at the time of the events I'm going to tell you about, Millie had just given birth to twins, Tamiel and Trevor. Unfortunately, there was malpractice during the delivery, and poor little Trevor was deprived of oxygen for a long enough period to cause him to have severe medical problems. He had brain injuries and massive medical problems, but was a lovely little boy, a sweet little boy. He couldn't talk, but he could communicate verbally, but he needed extensive medical care. There was a lawsuit against the hospital, against the doctors, settled at the last moment, and many millions of dollars were given to the family to take care of the little boy, Trevor, in a trust fund, and the money was there to pay for his nurses, to pay for his medical care, to pay for his hospital bills. While that was going on, Motown decided to leave Detroit. How could you do that? How could you be the Motor City and leave Detroit? But they're leaving Detroit, of course, to go to Sunset Strip, to go to LA. You go to LA today, you see the big Motown sign on Sunset Strip. And LT went from Detroit to LA, following the company. He had a life that got him into constant trouble. Gambling debts, drug debts. He was constantly in peril. And he gets to a point where he sees no way out. And so he comes up with the most evil scheme you can imagine. He figures, okay, if I can murder my own son, Trevor, and murder my ex-wife, Millie, who I hate now, all the money will come to me. That's his theory. But of course, he's a music producer. He doesn't know anything about how to kill people. He lives in LA. So through connections, he hooks up with a kind of low-level crook named James Perry in Detroit. James Perry had been in and out of prison a bunch of times, all on sort of petty things. He was, you know, he had a card that said he was a preacher. He could solve problems for you, all right? The two get together in a pool hall, and they strike a deal. And the deal is, if Perry will go to the suburbs of Washington, that's where Millie and her family are living now. She's using the Washington airports for her American Airlines hub. And if James will go there and kill Trevor and kill Millie, they'll split the money 50-50. They'll each walk away with a few million. They agree. Now, Perry had a problem. He was a decent crook, but he'd never killed anybody before. He had no idea. How do I go from Detroit to Silver Spring, Maryland, and murder 2 people? So we did some research. It turns out there's an American publishing company in Boulder, Colorado named Paladin Press. Paladin was the publishing side of the same sort of publishing partnership that still publishes Soldier of Fortune magazine. Paladin Press had about 200 titles, but it had a group of books in what it called the Burn and Blow series. And these were books that basically would train you in techniques of violence. And one of the books, I meant to bring it today. Our house is being remodeled. We can't find anything. We got tarps over all of our bookcases. So I was looking today, you know, trying to figure out, well, like, where are my snow boots? And then, where's my book? But I couldn't find it. But the book is called Hitman, a technical manual for independent contractors. And it tells you how to go into business as an assassin. It has technical details, it has charts, it has chemical formulas, it has ways to re-engineer your gun so that ballistics can't trace it. It tells you the steps you take. It has fascinating psychological training, the way you get yourself psychologically trained to do the job. It tells you everything from A to Z. It even tells you what to charge. Gives you the market rates, $170,000 to kill a federal judge, $150,000 to kill a prosecutor, right in the book. So this is before internet orders. Perry calls Boulder, asks the operator if the book Hitman can be mailed to him. She says yes, and we have a sale today. If you want, for $40, you can get Hitman and also how to make and dispose of a disposable silencer. Perry says, I'll get it. He gets the books. He follows the instructions in the Hitman manual to a T. He follows them perfectly. He makes one major mistake. He didn't get rid of the book. Through brilliant police work, the murders are detected. In the middle of the night, L.T. Horn is in L.A., Perry is in Silver Spring. Perry gets into the house, he breaks in, he takes Trevor's oxygen away, the alarm starts to go off, he freaks out, he shoots Trevor through the eyes, Millie comes running down the stairs, he shoots her through the eyes. The book tells you shoot through the eyes because the blood won't spatter. And then he escapes. Everybody right away suspects L.T. Horn. He's the man with the motive. Cops in L.A. go there. He acts like he's chagrined, like he's shocked, you know. They say, where were you this night? He shows, well, I'll show you where I was. He goes to the TV. He pops in a cassette recording, a VCR recording. Remember that when we used to have those things with little tapes on them, so you put them in there? And it shows him at the very moment of the murder watching a late night broadcast of CNN, and he's got the timestamp on. And he stands in front of the TV next to the timestamp while his girlfriend is filming him. So right away the cops know he had to do it. Who the hell does that, right? It's over alibied. But how do they connect? How do they figure it all out? Through brilliant police work, they're able to triangulate phone calls, they're able to put leads together, and they get their eye on Perry. They go to Perry's place in Detroit, and they find that he had bought the Hitman book, and he'd bought the disposable silencer book, which he used, and he'd followed them to a T. Both men are tried for murder. Both are convicted. The book played a central role in the conviction. So the families of the victims, really 3 people died. A nurse also died that night. It was horrible. The families of the victims, they're pleased that there are these murder convictions, but they're mad as hell at the publishers of the book. They think the book was part of the murder, and they think the book publisher should answer. So the family lawyer comes to me. I had been involved in First Amendment cases, and says, my clients want you to sue the book publisher. I said, no way on earth. You can't sue a book publisher. The book didn't kill these people. I feel bad the book didn't kill these people. He pesters me for months. He comes, he tries to buy me a beer. He comes into my class one day while I'm teaching. I finally said, I'm never going to take this case. You can't win this case. The First Amendment protects the book publisher. He said, will you at least read the Hitman book? Because I hadn't read it yet. I just had the idea. So I figured it would get him off my back. I read the book. I read the book in one night. My kids were with me in the house with 5 kids on it, two daughters then. The book had such an impact on me. In the middle of the night, I had a nightmare. I got up, I took the book, I took it outside, and I locked it in the trunk of my car. Because I felt the book was almost like an evil talisman, like it was itself emanating murder. And I didn't want it in the same house with my children. Stupid, irrational. But I was overwhelmed by the book. And I had this terrible problem as a lawyer. Emotionally, I hated this book. I hated this publisher. Intellectually, I kept thinking, but we can't win this case because of all these First Amendment doctrines. And I brooded and I brooded and I brooded, and one morning I came up with a theory as to how you could make an argument that the book was not protected by the First Amendment. First, I made the argument that it was a kind of incitement. You know, in the January 6 uprisings, there's been all this discussion all over our society about whether Donald Trump incited the riots, who incited it. It's a very high legal standard. You have to intend to incite imminent lawless action, and it has to be likely to produce the action. Well, that doesn't work very well for this book because the dude read the book. It took him months and months and months to commit the murders. The book had been out 10 years. So how do you get past that? The theory I came up with was, if the purpose of the publication is that once you get it in your hand, you start to plan the murder, to train yourself for the murder, that could meet the standard. But the other theory was, you know, maybe we need a new First Amendment doctrine that says, if you train people to commit a crime with the intent that they use the training to commit the crime, maybe we shouldn't call that incitement. Maybe we should call that aiding and abetting a crime. And I ended up arguing this up and down the court system. And the biggest moment came when I argued in front of 3 federal judges. I said, imagine a guy wants to murder his wife. And he goes to a friend who is a chemist. And he says, can you give me the formula that I can slip in the coffee and she'll die and it won't be detected? Well, if we discovered that, we would all agree the chemist is guilty of aiding and abetting murder. What do we know about this book? We know that the publishers have admitted that they marketed the book to train people to commit crimes. And they say, well, most people read the book and they never commit a crime. Sure, but they know some people will, and they're fine with that. And there's no moral difference between the two, I argued. And it crosses the line to aiding and abetting crime. Well, all those people I'd written the book for, written the amicus brief for in the Falwell and Hustler case, they all entered this case against me. It's like having the whole free world of free press against you. I was called a traitor to the First Amendment. I had one defender, famous jazz writer and activist named Nat Hentoff, who wrote for The Village Voice and New Yorker magazine, and I knew him as a jazz writer, but he also was he said I was no traitor to the First Amendment. I have his like article framed, you know, somewhere. All right. Well, we ended up winning the case. And this one was also made into a movie. I wrote a book about the case. And this time, I didn't try to write the movie myself. I sold the rights to FX, and it was the first made-for-TV movie ever done by FX. Timothy Hutton played me in the movie. It was fun. The movie is still controversial. The movie's not that great, to be honest with you, but television's come a long way. But I'm still pilloried. And when I teach these classes, and I'm going to end with this, every class I teach, half the students believe I was on the right side, half the students believe I was on the wrong side, and it flip-flops constantly. Of course, it's a free country, and they're entitled to their views, as are you. So I've talked too much. I'm happy to take your questions. Take your questions and include in the streaming video, folks. Mm-hmm.
So today, if contents of that book were published by Facebook,
Mm-hmm.
Would Facebook be in the same position as the book publisher?
Sure. So the question is, today, if the book were published by Facebook, what would happen? So let me first tell you a story. In the Hitman case, after we won in all the appellate courts, we were ready for the jury trial. So it was kind of weird. It was pre-appealed. That's the way the case played out procedurally. So now we were going to have a jury trial. As we were picking the jury, the horrible events at Columbine, the Columbine shooting, now we've had so many of those, but one of the really caused the whole country to be in a funk. And there were rumors that the kids had purchased books from Paladin Press. The case settled very generously for my client. It's confidential, but very generously for my client. As part of the deal, my client demanded that they turn over every copy of the book because they didn't want it out in the marketplace. I was nervous about this because what the heck were we going to do with them? And I figured we'd have a truck of 300 books or 3,000 books. They sent us 3 books because our lawsuit had caused the book to be a bestseller. And it was flying off the shelves because people were worried the book could get banned. I want it before. It was terrible, right? So here's what happens. They turned it over, they filed these affidavits, they said these are the only copies in existence. So I was able to say to my clients, who are still very emotional, we have the only copies, they've said there's no more. You know, we can't help that there's books circulating in used bookstores and stuff, but at least it's not marketed. So I came to class after the settlement, and the news had reported that there had been a settlement. And half the class had been on my side, half the class had been on the opposite side. And the students wanted to know how the case had settled. And I said, well, I can't tell you how much money it was, but we did make the book no longer on the market. You can't get it anymore. Student shoots up his hand. Yes. Student shows a laptop computer. Says, the book has been scanned and is now available on the internet. And you know what my response was? What is a scan? And what is the internet? We didn't have email. It was just the beginning, you know, like it was AOL and CompuServe. You know, I'd never been online yet. I didn't know what it was. So now you can get it anywhere. And I'm confident that Osama bin Laden got it and used parts of this and other books to write the training manual for Al-Qaeda, the Afghan book of jihad. It's a different story. Could you sue Facebook? The answer is 100% no. Because of a law that's in front of the Supreme Court right now. I think there had been an online person that wanted me to talk about this. It's called Section 230 of the Communications Decency Act of 1992. That's a mouthful. But it is a federal law that makes an internet service provider, Twitter, Facebook, Instagram, the local web page for somebody that's doing things in Manchester, Vermont, doesn't matter. If you are the provider, you cannot be sued for content posted by other people. And it is, I think, a law that's wrong. Of course, people like Google and YouTube, they love it. I think it's wrong. I don't think it's what Congress ever intended. It creates a real warping of our legal system, and I hope that either Congress or the Supreme Court curtails it some. A lot of people hearing this would hate me for saying that because they love it, because it's what makes the internet so free. But it means basically, if you can catch the person who did it, who wrote it, you can go after them. But you can't go after the big controllers.
You can't go after the publisher. It's the publisher, basically.
Right, so so this is more than you need to know. In traditional law, traditional tort law and First Amendment law, if you are the publisher of somebody else's statements, you adopt the statements as your own and you are liable for them. So if you're the New York Times and a person does an op-ed piece for you and they defame someone, you, the Times, are deemed to be a publisher. And if you think about it, almost all news broadcasts, almost all news stories, the thing that really puts the knife in is a quote from somebody else. And so the law has always been, you don't get off because you're quoting somebody else. You don't get off because somebody else wrote it. You adopt it as your own. That's the ancient rule, which I think is a good rule. Now, there are exceptions. Like if the person says it in court, there's no liability. I told you I was involved in the Dominion case. I can't talk much about that because it's a live case and I'm involved in it. But I can talk about this because it's public record. Fox's defense in the case is that we didn't say that Dominion fixed the election. We reported that Donald Trump and Rudy Giuliani and Sidney Powell are saying that they fixed the election. And also public record, what Dominion is saying, what I argued in front of the judge when I argued the case is, no, that's not the law. First of all, if you adopt it as your own, if you give them the platform. And secondly, if you really watch the broadcasts of Lou Dobbs, of Maria Bartiromo and others, they are endorsing this. They are using their own voice. Sometimes it's subtle, but they are. We don't know where that case will end up, but that's because that broadcast took place on Fox. That same thing put on an internet platform, let's say that Fox owns, and when someone posts it, they'd be immune for that. It's a really weird asymmetry or something in the law.
Thank you.
Sure.
Can I change subject?
Oh, yeah.
One of the things that I have found very troublesome recently is the hostility, particularly on college campuses and in universities, toward tolerating posing or speech that people feel is, quote, untruthful or whether it is or isn't, but it's usually political speech. It usually comes from right-wing sources. And you have this sort of hostility now toward the First Amendment being exhibited in what would normally be considered progressive institutions.
Right.
Some things, now you have a lot of experience in academia, and I was wondering if you could comment on that phenomena and how seriously a threat do you see it being?
So it's really the questions about speech on campus and whether this generation of students and this generation maybe of faculty members don't understand free speech and are intolerant towards views that they find offensive. And you said, well, I've been an educator for a long time, and it's true. I've been involved in many of these controversies where I've had to make decisions regarding the controversies. But more important than that, I'm a dad, and some of my children are the very people that you're talking about who think that administrations should ban a lot of this speech. I was a first-time college student, and I went to college as a football player. I know it's hard to believe. I went to Yale to play football. I mean, I didn't even know where Yale was. I went to Yale to play football. And, but then later, one of our children, my daughter, got into Yale like for bona fide reasons. And she graduated 5 or 6 years ago. I'm very, very proud of her. She's a young law student now. She's a night student at American University in Washington. And she just took the First Amendment course. She called me on the phone and we talked about these things. But she, I think, has no problem with conservative viewpoints. Even what you might think of as an extreme conservative viewpoint that she thinks is intellectually intolerable, many, I think overwhelmingly, this generation of students are okay with that. Not all of them, but overwhelmingly, and faculty members. But her problem is hate speech. Her problem is an attack on people based on their sexuality, an attack on people based on their gender, an attack on people based on their race. And what she says to me is, how can you defend that, Dad? How can you possibly defend that? Because it has no intellectual content, it is purely there to hurt, and it isn't civilization sophisticated enough that there are some lines we can draw. Some lines we can draw between what's evil and what's not. And I know this is maybe a longer answer than you want, but I have come to abandon the view that this generation of students doesn't understand the First Amendment. I have come to the view they understand it differently. And their different view also has a long pedigree in American thought and in American constitutional law. So the two theories that I often talk about are the marketplace theory, which is this modern theory. It's like the Jerry Falwell case. It's that you let the different sides battle it out and the government doesn't censor. But there's another theory that has a long pedigree as well called the order and morality theory. And it comes from a very famous case, Chaplinsky versus New Hampshire. I'll be teaching this the next time I teach my First Amendment class, tomorrow in fact. And there's a famous line in that case in which Justice Frank Murphy says, there are certain kinds of expression that have never been thought to cause any First Amendment problem, and he gives a list of some of them. And then very elegantly, in one sentence, he says, it's been well observed that these utterances form no essential part to the exposition of ideas, and whatever slight value they have is outweighed by the societal interest in order and morality. Order meaning you don't want to have violence caused. Morality means it's against our value system. And for a long time, I was of the view that that was wrong, that that was antithetical to free speech, and that the better view is this more modern marketplace view. But what I've now come to, and my theory was, it used to be that the order and morality theory ran the show, and then in the 1960s, everything changed in all of our society. You had Vietnam, Civil War, the Beatles, Elvis, rock and roll, and First Amendment law flipped upside down, and we went to an anything goes version of the First Amendment. I now have decided that's not the right way to think about it. And what we now have in our society is both systems side by side. In the open spaces of our marketplace, in most of our internet spaces, on the streets, on the sidewalks, the marketplace idea reigns. You cannot ban the Ku Klux Klan from marching through the streets of Charlottesville, for example. A lot of people wish you could, but you can't. You can't ban Nazis marching through Skokie, Illinois. You can't keep the Klan from having a racist rally if they're not inciting people to riot or threatening people, okay? A lot of people can't accept that. But in other spaces of our society, we revert to the order and morality theory. For example, in employment. So you can be very racist, you can be very sexist out in the park, but there are things you better not say at work, or you violate Title VII, and your employer not only can fire you, but has a duty to fire you. In a university classroom, you have to check certain things at the door. As the professor, you have to check certain things at the door. Not ideas, but certain expressions. I couldn't attack someone based on their sexuality if they're sitting in front of me and I'm a professor. I'd be fired for that. And if you think about our society, it's fascinating. It's kind of like a gerrymandered roadmap. There's the free speech areas, and there's the place where we require civilization. We require decency, which then poses the fascinating question, what's a college campus? I told you I went to Yale. I wasn't much of a student, at least until I hurt my knee in football, then I became a student. I figured, what am I going to do now? So maybe I better make some use out of this. And I was fortunate to have a Dante scholar that I got to know named Bart Giamatti. Elegant Dante scholar. Who would have thunk a Dante scholar would become president of Yale but more impressively, the commissioner of baseball, the man who had the courage to ban Pete Rose. And he once said this of a modern campus: it's a free and ordered space. He's combining the two thoughts. There are parts that are free and there are parts that are ordered. So it's a long-winded answer to your question. And I certainly am with you on the side of saying you cannot shut down viewpoints you don't agree with. I will tell you, I once taught a course alongside Judge Robert Bork. We co-taught the course together, one of the most famous conservative intellectuals of all time, and me, a kind of centrist liberal. So that's an example of my view, that those views deserve to be there. But I think when you get to hate speech, it tends to turn on nuances. How direct was the speech? What was the environment? Was it one player on the soccer team against another player? Was it a coach to a student? Was it a captive audience like inside a classroom? And I think there may be instances in which a university has an obligation under Title IX or other things. Can I tell you one quick story about Judge Bork? Because it kind of goes with free speech. I was at the University of Richmond at the time, and I had a friend at the university. He wasn't a lawyer. He was a speechwriter. He had been a speechwriter for Ronald Reagan. So you know the guy is good, because Ronald Reagan could flat out deliver a speech and wrote some brilliant speeches. And he wrote, speeches like the famous speech that President Reagan made when the Challenger disaster took place. They go to kiss the face of God. I mean, it brought tears to your eyes. And I don't know if he wrote Secretary Gorbachev, tear down this wall, but he was in that cadre. He was a conservative intellectual like you would expect. He was buddies with Margaret Thatcher and Ed Meese and Ken Starr and Ronald Reagan and all that crowd. His name was Gary McDowell, and he and I disagreed on every issue that there was, but I loved his company. And one day I said to him, what are you doing this weekend? And he goes, well, me and my wife are going to go see Bob Bork and his wife. And I go, who? He says, Judge Robert Bork. I said, you call him Bob? And I went, well, of course you would, So I said, what's he doing? And he says, well, he's bitter because he was defeated for the Supreme Court. He's mad at American universities because they basically kept him from making it to the Supreme Court. He's doing this work for these conservative intellectual think tanks like the Heritage Foundation and others in D.C., but that's what he's doing, and he's writing books. And I said, well, that's a shame, because I heard he was a great law professor. And why doesn't he go back to Yale? And my friend Gary laughed at me. Are you kidding me? There's not a law school in the country who would hire him. He's damaged goods. Not a law school in the country who would hire him. And stupidly, I was the dean of the Richmond Law School. I blurted out, as I can sometimes do, well, we'll hire him. I said that with no authority, no authorization. And he goes, he's like laughing at me. I said, go tell him that I'd like him to think about coming to be on the University of Richmond law faculty. He can come part-time, he can come full-time, we can work out a deal. And so Gary reports back the next week. I said, what did he say? He goes, well, he knows you. He cited some of your stuff and some of his opinions. He likes you, he respects you. He says, no way on earth, I'm not going to do that. I'm not going to go there and have people mock me and throw tomatoes at me. Like, oh, that's sad. That's sad. He should be teaching in law school. I said, would he let me come visit him? He said, okay, I'll ask him. A week later, yeah, he'll let you come buy him lunch or something, but he said the answer is going to be no. So I go to meet him at the Four Seasons in D.C. and try to ease into it. So it turns out we're both lifelong Chicago Bears fans. So we got that. And he loved Yale football. So we got that. And he was a Marine, and I admire the Marines. I talked about my dad serving. He liked that. And then we started talking con law. I started asking him about this and that and this and that. We agreed on some things, but he loved talking about it. So I said, Judge, you got to get back in the classroom. You got to come. Come on down. We'll pay you a lot of money. We'll pay your expenses. You can stay at the nice hotel in Richmond. Zip back and forth, You'll love it. He goes, no, I don't want to be mocked. So I called an audible. I said, why don't you and I teach the course together? We'll teach a course, we'll call it The Constitution and American Culture. We'll talk about anything you want. You'll have your views, I'll have my views. We'll often disagree, sometimes we'll agree. We'll let the students come in on the conversation. And he got misty-eyed. And he said, that's what it used to be like at Yale with me and Alexander Bickel, who was this famous other common law professor. I said, come on. He did it. So we ended up doing that. And as you would expect, we had every movement conservative within 300 miles, like wanting tickets. It was like hotter than tickets to Alexander Hamilton, you know? And we ended up having this huge auditorium. So we had about 150 students in the class. We opened it up to law students and undergraduate students. And then we had a balcony and guests would come. I've never seen, for a law school class. And we had a ball. And I said, Judge, you want to keep it, you want to keep it like the dormant commerce clause and stuff like that? That won't be. He says, no, I want to talk about abortion. I want to talk about affirmative action. I want to talk about free speech. We talked about all the biggies. We talked about the Saturday Night Massacre and his role in that, and Watergate. And he and I became friends. And we only ever had one fight. And the fight, and I'll end tonight with this, fight was, he was a hard-drinking, hard-smoking, eating guy. I mean, part of the fringe benefit was I would always take him to a nice restaurant after the class. And we went one time, and it was my wife and I and Judge Bork and his wife. And he has his cigarettes outside, and he comes in, and the waitress is asking for our drink orders. And I said, I'd like a Grey Goose martini straight up with a twist. And Judge Bork excoriated me. He said, that's not the original intent of those who invented the martini. You cannot order a Grey Goose vodka martini. Martinis must be made with gin. Now, it's a free country. You can order that drink, but don't you ever call it a martini again. And I realized he was right. I'd violated the original intent of the constitutional creators of the martini. Thank you, folks, for having me. It's been a delight. I've really enjoyed it.